I am here to urge the immediate reinstatement of a lawyer whose 60-day suspension has just entered its 878th day. This court rejected Bar Counsel's request to suspend him indefinitely, but now asks that this court treat him as if he were. This court had the option to sideline him indefinitely, and a majority found that that would not be necessary to protect the public. To sideline him indefinitely would take him away from a vulnerable class of clients that he represents. And so we had a 60-day suspension. I will argue that contrary to Bar Counsel's objections, we cannot apply standards to his reinstatement that exist for indefinite suspensions, that there is no basis to deny reinstatement, and that my client has more than atoned on day 878 for any flaws in execution at the time of his suspension. This is a case in which Bar Counsel has taken advantage of the good faith of her opposing counsel and opposing party. Bar Counsel has prolonged this suspension through insatiable demands for records that are not required in cases of this nature, waited months to conduct what she termed cursory reviews of records, and ignored the evidence that actually was produced. Now, Bar Counsel wishes to exploit her dilatory tactics to apply the rule for longer suspensions. As I look at the chronology of communications exchanged between Ms. Lawless and Mr. Bonsip, I understand my predecessor's frustration. He bent over backwards to meet increasing demands. In the fall of 2019, he produced reams of documents. But every time he would produce documents, he would get requests for even more documents. Documents that might be required in connection with suspensions exceeding 6 months or indefinite suspensions, but financial records that are not required in cases of this kind. So they were continually placed on an ever-increasing scavenger hunt. By March 31st of 2020, months beyond a time in which Mr. Singh should have been reinstated, he completed a pretty extensive scavenger hunt to produce the financial records requested. And what they were met with were repeated apologies from Bar Counsel for a delay in responding to the documents that were produced, and continued frustration on the part of Mr. Bonsip, who wanted to move this matter along. He even provided full and free access to everyone in the law firm and the attorneys to whom my client delegated day-to-day responsibilities to confirm that he wasn't practicing law, that he wasn't profiting from the practice of law. He was trying to keep the firm afloat to survive what was supposed to be a very brief hiatus from practice. And unfortunately, Mr. Bonsip's good faith wasn't met with any reciprocation.
Mr. Kramer, can I ask you, and I apologize if this is in the record and I've just overlooked it, but has Mr. Singh's law firm in either of its incarnations during the period of suspension, has it taken in revenues of any kind from legal clients?
Yes, it has. But Mr. Singh has not profited from that. In fact, we provided the financial records as well as an affidavit of his accountant, which showed that neither he nor his wife, contrary to Bar Counsel's allegation, ever profited. In fact, he sustained losses keeping it afloat.
But what I guess my question is, what lawyer at Mr. Singh's firm has provided legal services during the period of suspension to justify the receipt of revenues for providing those services?
Timur Edib and Veronica de la Vega, two licensed attorneys, mostly immigration lawyers, provided that information, provided those services, and of course, they profited from those services, but Mr. Singh did not.
Well, I guess I know that I'm going into some of your rebuttal time, but I just want to make sure I understand the mechanics of how all this worked. Tell me if I'm getting any of this wrong. Clients paid Mr. Singh's firm, and then the firm paid the two independent contractor lawyers by the hour. Is that correct?
I believe so.
So was there like a fee split between the law firm and the independent contractors? Was that a fair characterization of what was going on?
No, I don't think that's a fair characterization, because basically what we did here was to keep the firm afloat. That means not only paying the independent contractor attorneys, but also paying the staff that handled these cases. So it was simply a matter of protecting the clients, preserving the firm so that it could continue serving clients during what was supposed to be a 60-day hiatus. That's what you do when you're suspended for a brief period of time. You do what you need to do to keep the doors open, to keep the cases going through someone else. And as long as you're not profiting from services rendered during the course of the suspension, which was absolutely not the case here, that's exactly what you're supposed to do, Your Honor. Thank you.
Ms. Lawless, you may proceed.
Thank you. Good morning again. Rule 19742 is not rough guidelines. It's not estimations of what is supposed to happen when an attorney is suspended from the practice of law. Rule 19742 does not distinguish between an attorney who is suspended from 30 days versus an attorney who is indefinitely suspended. To be clear, the investigation that was done in this case was associated with what was then 19742, now Rule 19741. The investigation that was conducted was not part of a 19752 petition for reinstatement or a 19751 short form petition for reinstatement. So for the respondent to say that that there were flaws in the execution is essentially an admission of a complete failure to comply with the strict requirements of Rule 19742. Those requirements are detailed. Those requirements are outlined in 3 pages of a rule. In the opposition to the petition for reinstatement, I outlined and highlighted the larger pieces of those failures. What we do not know sitting here today is why at the time the firm was sold, approximately a month ago, it had over 100 clients where Rule 19742 requires that a suspended attorney return client files and property to all clients. What we do not know is how and why.
Ms. Lawless, isn't there a difference between the attorney and a law firm that employs the attorney? I mean, what happens in a 50-lawyer firm and the senior partner is suspended for 60 days? Can the firm continue to exist and provide services?
So in those instances, Your Honor, the client has retained the firm. And what happened in this case is the PC that was the original entity at the time Mr. Singh was suspended. Mr. Singh was the sole partner, principal, operator of this firm. There was no other attorney involved.
Yeah, but he hired independent contractors to provide the services. Was he required to sell his shares in the corporation?
No, Your Honor. He was required to cease from the practice of law.
Okay, so what's the evidence that he was practicing law in that time period?
Mr. Singh was the only signatory on the firm's 2 attorney trust accounts during this period of time, while Mr. Kramer represents to the court that the 2 independent contractors were paid on an hourly basis for the services that they provided to the clients of what he purports are the firm. That evidence was never produced to me, and that evidence is not in the record before this court. As I understand it, the 2 independent contractors operated their own law practices and came in as successor counsel for clients. That means they would have They would have had their own individual retainer agreements with the clients. They would have accepted the client's funds. They would have used their own attorney trust accounts. And what we have here is evidence that Mr. Singh, as a suspended attorney, continued to receive client funds during the entirety of the period after his suspension. He has not provided any explanation for why he received those client funds.
Where did those funds go?
Those funds, some went into his attorney trust account. He has not maintained attorney-client ledgers. He has failed to produce any of those ledgers. Some of those funds went into his firm's operating account, and he has not provided any explanation about why client funds were deposited directly into his operating account. What Mr. Singh did in this instance was attempt to evade his 60-day suspension. What he did was attempt to bring someone in to cover his cases. He failed to give adequate notice to his clients that existed at the time of his suspension, and was hoping that he would, in essence, just pause the practice of law for 60 days and pick right up where he was 60 days thereafter.
Ms. Lawless, if you were a sole practitioner with a PC, how could you ever comply with the rules in a 60-day suspension without transferring your shares?
Your Honor, the rule does not require the transfer of shares. The rule.
I understand that. I'm trying to figure out how you could comply with it if you still have a law firm with staff and you're the sole practitioner. I'm trying to figure out who signs the checks in your trust account, who operates the firm during the 60-day suspension.
Right. So the rule is specific that you cannot sign trust account checks during a term of suspension. So the rule provides that there is a 15-day period of time to wrap up some matters. There's 30 days to wrap up additional matters. In this case, Mr. Singh was given an additional 30 days on top of that to wrap up what needed to be wrapped up so that he could cease the practice of law pursuant to this court's order.
So it sounds like he would have had to wrap up his practice.
Yes, Your Honor, that's what Rule 19742 requires. It requires that all clients be notified. It requires that all files be returned to active clients. It requires that all unearned funds be returned to clients. That is what the rule requires. There is no exception for a sole proprietor. There is no exception for a solo practitioner. What the rule has built into it is a 15 days and a 30 days by which an attorney can get his or her affairs in order. And
It looks like he attempted to comply by retaining counsel, and it may not have been the right solution, but he attempted to get his wife on he was attempting to comply with this rule that seems like it's set up for failures if what you're suggesting is true for a sole practitioner in a 60-day suspension period.
Your Honor, all I can do is read the rule as it's written, and I'm mandated with enforcing compliance with the court's orders of suspension and disbarment, and enforcing compliance with the rule as it's written. There are plenty of practitioners, including solo practitioners, that have successfully wrapped up a practice for brief periods of time. And whether that means transferring a client file to another attorney who's going to take on and cover that matter until they're reinstated to the practice of law, whether that is disengaging with all clients, whatever the particular case requires, whatever the attorney's practice requires, is what they're required to do under this rule.
So they would be required to terminate their staff if they couldn't pay them?
No, Your Honor. No, Your Honor. But what that is ongoing concerns of the firm. It's not receiving client funds. It's not depositing and making disbursements from an attorney trust account. It's not receiving funds for consulting on new client matters. It's not failing to file motions to withdraw in ongoing matters. We have seen this in so many different ways in short suspensions. And a perfect example of this is where there is a high volume practice, particularly, for example, say a personal injury practice, where during the period of suspension, say, for example, settlement checks are coming in for client matters that had been settled prior to the term of the suspension. The appropriate mechanism in that instance is to have a conservator appointed to control the attorney trust account during the period of suspension. I have worked with attorneys and practitioners to do that on numerous occasions. The appropriate mechanism is not to appoint your non-attorney wife as director of a law firm in an attempt to do through her that which you cannot do and are prohibited by an order of suspension in doing for yourself.
Ms. Lawless, I have a question.
Yes, Your Honor.
The petition for reinstatement in this case was filed under Rule 19751 because it was a 60-day definite suspension. Under that rule, when Bar Counsel receives the petition, Bar Counsel has 5 days, I believe, within which to file an objection with the court and serve the objection on the petitioner.
Correct.
That rule, as I read it, doesn't authorize an investigation or a request for records. So
Yes,
under what authority were you acting when you were requesting the financial records?
under Rule 1942, Your Honor, which is what this investigation was from September of 2019. This was an investigation under Rule 19742, specifically 742D, which says Bar Counsel shall enforce the order and the provisions of this rule and shall investigate information that the attorney has violated Section B or C of this rule. Under Rule 19742, the remedy upon completion of an investigation is to file for an injunctive relief or to file a petition for disciplinary or remedial action, which is what was done in this case.
And how do you read Rule 19742 and 751 together? Once the petition for reinstatement is filed and the suspension period is over, it would appear at that point the case is before the Court of Appeals, and we would either grant or schedule for a hearing pursuant to 19751. I mean, at some point, Bar Counsel's investigatory powers under 19742 must come to an end, right?
Yes, Your Honor, there's been no investigation since the petition for reinstatement has been filed. And so the petition for reinstatement was filed. And so essentially the way that the procedural posture of this case was, there was a 19742 investigation almost immediately following Mr. Singh's suspension, beginning with his failure to timely provide required information to Bar Counsel. And at the outset of that investigation, there was a very quick turnaround based on the information that was provided through his then counsel, Mr. Bonsip, because I was well aware that he had 60 days and could petition for reinstatement under Rule 19751. And a requirement for petitioning for reinstatement under Rule 19751 is that the attorney certify to this court that they have complied with Rule 19742. And so in order for me to respond to an attorney's assertion that they have complied with Rule 19742, the rules authorize Bar Counsel to conduct investigations pursuant to that rule. So all of this
time limit, there's no time limit before the petition is filed under 19751. So is it your position that Bar Counsel could investigate indefinitely? Let's say the suspension is 60 days, but as in this case, the petition isn't filed within 60 days, that you could investigate for years if no petition is filed?
Well, I would hope I wouldn't investigate for years, but honestly, what happened in this case, and I think what the record bears out, is every time information was provided by Mr. Singh, it raised additional concerns and questions about Mr. Singh's compliance with Rule 19742. For example, why are you writing checks from your attorney trust account where Rule 19742 specifically prohibits the use of any bank accounts? And then when I request the client ledgers, the deposit items and the disbursement sheets that are disbursement items that an attorney is required to create and maintain pursuant to Rule 1.15 of the Maryland Rules of Professional Conduct, and advise that those don't exist, then what do? Then I issue a subpoena and I get the bank records. And all of this is prolonged for a variety of reasons. Yes, I was not as responsive as I could have been. There were also extreme delays in Mr. Singh providing responses to information to my office. And I think that one of them was at least a 5 months or almost a 5-month period of time between my request for information and him providing the information that was responsive. And then once that information was provided, it was incomplete. And so the investigation that was conducted was pursuant to the suspension order and Rule 19742. The information that was provided by Mr. Singh was either inadequate or raised additional questions about his compliance, not only with Rule 19742, but the potential that he had violated other rules of professional conduct, including potentially engaging in the unauthorized practice of law during his suspension and affiliating his firm with a non-attorney to manage the practice during the term of his suspension, his failure to create and maintain appropriate records for client funds that he continued to receive during the period of suspension. And that's why we ended up where we were. And that's why the procedural posture of this case is what it is. There was never an investigation done pursuant to Rule 19751 or Rule 19752, because obviously this petition wasn't filed pursuant to Rule 19752. And what I did request, yes, Your Honor.
I'm sorry. I had a question. There's, as I'm sure you know, there are some notes from Mr. Bonsab in the attachments that Mr. Kramer filed. And it indicates at a certain point, I think in June last year, you had indicated there were two ways to go. One was to file a petition for reinstatement to which you would object, or wait and you would file the PDRA. Were those notes accurate?
Yeah, yes. So we had, I believe it was in the, in March of 2021, the investigation under Rule 19742 was completed. And at that time, I advised Mr. Bonsap, and I think this is in an email that's in the record before this court, that I intended to file a petition for disciplinary or remedial action pursuant to Rule 19742. At that time, Mr. Bonsap asked if he and I could discuss the matter before any further action was taken. He and I did have a telephone call on June 15th, and we talked about sort of the uniqueness of this case and sort of how there were two parallel issues, one being him wanting to petition for reinstatement and the multitude of issues that existed associated with his reinstatement, and two being pursuing additional discipline in the terms of a petition for disciplinary or remedial action. We were supposed to reconvene and have further discussions about how and if that would be handled. There was never any further conversation. Apparently, Mr. Singh then retained Mr. Kramer, who filed just a short form 19751 petition without identifying to the court any of the issues that had existed that me and Mr. Bonsap had discussed in detail over this extended period of time.
But the Bonsap notes indicate that you had suggested alternatives. One was that they would file the petition for reinstatement and that would kick it off, or you would file a PDRA, but it looks like
yes.
both
and so that's correct, Your Honor. And part of the issue was because there were so many outstanding questions that still exist, why this PPE loan was sought, whether Mr. Singh was responsible for the website that continued to be maintained associated with advertising and client matters, saying that Mr. Singh was providing services during the period of suspension. And so the question was, are we going to seek through this court a hearing in a reinstatement petition, or are we going to is he going to forbear filing a petition for reinstatement and we'll have a hearing in a disciplinary proceeding? Instead of doing that, he filed a petition without raising any of these issues for the court, asserted that he had complied with Rule 19742, which I think me and Mr. Singh both agreed, me and Mr. Bonsap both agreed was not the case, and attempted to gain reinstatement essentially without raising all of these issues that had been discussed at detail and at length during the investigation.
So the PDRA was filed, and what's happened with that?
At Mr. Kramer's request, I've held service on it. And I suggest to this court, because of the questions that exist in this file, that if the court is not inclined to deny outright the petition for reinstatement, that it be transmitted to the circuit court to be heard and determined consistent with the outstanding petition for disciplinary or remedial action, because all of the issues overlap. The petition includes allegations of violations of the rules of professional conduct that don't exist in the petition for reinstatement, but the underlying predicate, the underlying facts of the two are almost identical. And there are so many outstanding questions in this case. And honestly, I think that it was truly in bad faith that the petition for reinstatement was filed in the manner that it was done without raising any of the issues or apprising the court of any of the circumstances of this ongoing investigation, or the fact that I had made a determination that a petition would be filed pursuant to Rule 19742.
So we have the sworn statement of Timur Edib, who's swearing that Mr. Singh didn't engage in the practice of law, he didn't meet clients, and describing. And then we have the affidavit of the accountant saying they didn't receive any profits and they didn't receive, he or his wife. He admits that he attempted to put his wife on the trust account, presumably to write the checks. And now we know that Mr. Singh has had to sell his business. So he's not even in that practice anymore. What other questions? I can accept the fact that there was this trust account issue where it appears based on advice of counsel, he was trying to comply. It might not have been, had you read the rules correct, but what other questions are there out there if he wasn't representing clients in court, he wasn't meeting with clients? We have Mr. Edib's affidavit and the affidavit of his accountant. I'm trying to figure out what other open-ended questions there are that
Sure.
will protect the public from Mr. Singh being reinstated.
Yes, Your Honor. One is a complete accounting for the funds that were deposited into his attorney trust account for which there are no client ledgers. An explanation for why there were, I think it's over $300,000 went through his attorney trust account during the period of time that he was suspended, for which he has provided no information, and which neither attorney who he is affiliated with has said affirmatively that they represented those clients and that they provided services to those clients. We don't have any information about the paycheck protection loan that Mr. Singh purportedly obtained during the period of suspension, where those funds went and what they were used to cover. We don't have any information about why client funds were deposited into the operating account during his period of suspension, particularly client funds that bore notations such as for consultation or payment for attorney or those types of things. We don't know whether those are funds for services rendered by Mr. Singh prior to his suspension. We don't know if those are funds rendered to one of the two attorneys that he affiliated with, and if so, why were they deposited in Mr. Singh's attorney trust account rather than one of the other attorneys' trust accounts. We don't know whether or not Mr. Singh was responsible for the website that didn't have an affiliated attorney with that's been provided to this court that was posted during the entirety of his suspension. We don't know whether, when, how any of Mr. Singh's non-English clients were ever advised that he was ever suspended from the practice of law. As is contained in this file, as I think more than 50% of his clients were non-English speaking. Mr. Singh at the time of his suspension provided letters to his clients advising them of his suspension that were written in English only. During the 19742 investigation, I asked repeatedly for details as to how these clients were specifically notified that Mr. Singh was suspended. No information has been provided. Yes, Your Honor.
Isn't there information in the record that when the office manager or his assistant called all of the non-English speaking clients?
There's a general statement that she called all of the non-English speaking clients. There are no notes specific to any client. There are no.
But your statement, well, how do you know how many of what percentage of his clients do not read and write in English?
He identified for them for me, Your Honor. He provided the clients, he provided the client list and the letters that were sent to the client that were in English. I followed up with Mr. Bonsef asking how many of those clients could read English, and he identified, I don't have the number right in front of me, 39 of the 68 clients that he had at the time of his suspension were non-English speaking. He then stated broadly that his legal assistant, his Spanish-speaking legal assistant, advised the clients of his suspension. I asked for details, call logs, notes to a file, anything to indicate that each of these clients were actually notified in a way that they could understand that Mr. Singh was no longer licensed to practice law. None of that information has been provided.
But do we know whether it exists? If the receptionist or whoever the office manager was communicating with each one of these folks in Spanish, was there a requirement that she keep notes of each conversation?
Yes, Your Honor. Under Rule 19-742, an attorney is required to keep documentation of all steps that they take to comply with Rule 19-742.
So if she documents that I called these people and we have pleading saying that she did that, isn't that sufficient for compliance with the rule?
No, Your Honor. The rule is very specific that each client must be notified that the attorney is no longer authorized to practice law.
Do you
A
have
statement-
documentation that each client was notified in English?
That's correct. And,
Okay.
and information that the clients do not read English.
So we know that each client received a written communication, and we also know that the office manager claims to have followed up in Spanish.
Yes. Yes, and this is the same office manager that was found to not be credible in the underlying disciplinary case, Your Honor. And so these are the questions. I mean, when you ask about the protection of the public, I'm not even sure that Mr. Singh's current clients, the clients that existed, the 100+ clients that existed at the time that the firm was sold, ever knew that he was suspended from the practice of law.
So Mr. Kramer said something in his opening that, and I wrote it down, Mr. Bonsett bent over backwards to meet bar counsel's demands and provided full and free access to everyone in the law firm. Did you ever interview any of the folks in the law firm or
Yes.
speak to them?
Yes, we spoke with both of the attorneys.
And they didn't provide?
The attorneys were
sufficient-
not, no, because the attorneys were not involved with the handling of client funds. So what the attorney said is, I know the cases that I took. I know the cases where I entered my appearance as successor counsel, but they didn't have any access to the attorney trust account. Mr. Singh has always been the only person with signatory authority on that account. They have no information about how the staff is paid. They have no information about any of the financials associated with the firm. So no, I mean, yes, we spoke to them. We did an investigation, but it did not satisfy the requirements of Rule 19-742. And it didn't answer these questions about how a suspended attorney continued to have large amounts of money going in and out of an attorney trust account and no records associated with those funds.
So, Ms. Lawless, I have a question about the timing of this. You've mentioned that the investigation was done under Rule 19-742, which
Correct.
does indicate bar counsel may conduct an investigation that could result in a request for an injunction or a petition for disciplinary action. Why didn't that happen in this case until the petition for reinstatement was filed?
So the decision was made to file the petition, as I mentioned, in March of 2021. When I advised Mr. Bonsett, there was then a delay because he and I spoke about the matter. And then shortly thereafter, I think it was 2 weeks thereafter, the petition for reinstatement was filed without any further communication, follow-up, or conversation, which is where Mr. Bonsett and I had left it.
So you filed the petition for disciplinary action on July 30th at the same time that you responded to the petition for to the petition for reinstatement?
Correct. The petition for reinstatement was filed on July 5th. Me and Mr. Bonsett spoke on June 15th, and there was no communication between June 15th and the petition being filed on July 8th.
It just appears that there's this 2-year period that goes on, and there's no action by bar counsel's office until the request for reinstatement. And so
Yeah, Your Honor. So if you look at the timeline of the investigation, which was the order of suspension was July of 2019 with an effective date of August 16th, 2019. There's the initial communications back and forth between me and Mr. Bonsett, which results in a request for information that I sent to Mr. Bonsett. It's my Exhibit 25 on October 29th. Mr. Bonsett does not provide the information requested until March 31st of 2020. So 5 months later, that's, I think it's Respondent's Exhibit Q is his response to that. That information that he provides was incomplete. In the interim is the COVID-19 shutdown. So I didn't get a chance to review the information that he provided and respond to Mr. Bonsup until August 16th, when I had done an initial review. I apologize for the delay, and I asked for the additional, or asked again for some of the financial information. Mr. Bonsup then followed up with me a month later, we're September 2020. He then provides some additional information in October of 2020, but he had not provided any of the cancel checks, the deposit items, or the ledgers associated with the attorney trust account. And so it was in October of 2020 that I said, if Mr. Singh doesn't maintain that information, I can issue a subpoena to at least get those documents from the bank. I then followed up with Mr. Bonsup, again, based on the information that he had provided, again, noting that there were deficiencies, again, offering to issue a subpoena. That was in December of 2020. I then issued the subpoena. The bank records were produced to my office in January of 2021. We interviewed the two attorneys also in January of 2021. And then additional information was provided by Mr. Edib at the end of January. And by the beginning of March, I had reviewed the file, completed the investigation, and advised Mr. Bonsup that I intended to file a petition. So there really wasn't that much of a delay when you take into account the delay in time between Mr. Singh providing information requested and then the multiple requests for the information that had been previously requested, specifically about the attorney trust account and the maintenance of client matters or client funds, and the absence of client ledgers during the period of suspension.
All right. I've looked at the petition that you filed. It all seems to be related to violations of Rule 19-742, except there's an allegation of misrepresentations to the Immigration Service in that allegedly Mr. Singh signed a document entering his appearance.
Yes, Your Honor. On August 16th, the effective date of his suspension, what was mailed from his office were 2 G-28s, notice of entry of appearance, entering his appearance in 2 client matters. In those entries of appearance, he certified that he was authorized to practice law in the state of Maryland.
Right.
And in the petition, there's also allegations associated with Rule 1.15 trust account documents to be created and maintained and the like. I see my time is up. Thank you.
Ms. Lawless, I'll note that your time is up, but we certainly will entertain any questions from the court and add to Mr. Kramer's time if necessary. And I believe Judge Booth has a question.
I just had a question about the signatures, the entries of appearance. So those happened basically at the same time that this court entered the suspension.
No, Your Honor. The court suspended Mr. Singh on July 17th, 2019, effective 30 days thereafter. On August 16th, which was the effective date, Mr. Singh entered his appearance in 2 matters. And
did I see that he was on vacation during the time period when the opinion was issued?
That's what he claims. I haven't seen any documentation.
Thank you.
Mr. Kramer, we ran about a minute and a half into past the stopwatch. So that puts you back to 25 minutes.
Like the NFL, Your Honor. Your Honor, I'm told here that I exercised bad faith in filing a reinstatement petition that my client was actually invited to file by Bar Counsel. There are several problems in this case. I thought the rules of ethics applied to all lawyers. I am finding now that you can request documents, fail to review them, not even know what you've received, and misrepresent the contents of those documents to the court, misrepresent the law to the court. And I need to address this. Bar Counsel has made several misrepresentations here, both legal and factual. Legally, she told her opposing counsel, Mr. Bonsup, and you can see that in Exhibit W at page 141 of our appendix, that my client must divest his ownership interest in the law firm, that he must change the name of the firm, that he must close bank accounts. He told Judges Gould and Booth the opposite. In fact, under the rules, you do not need to do that in the case of a 60-day suspension. Websites, phone directory, they don't need to be changed. The firm doesn't need to be dissolved. Ultimately, thanks to her dilatory tactics, and I believe bad faith tactics, the firm had to be dissolved, essentially. My client had to relinquish it completely because he couldn't save it anymore. Factual misrepresentations. Ms. Lawless claims to have finished her investigation 4 months before seeking 30 more days to investigate, and then tells you she didn't do any further investigation. What she did do was to draft a petition for disciplinary action. She falsely accuses my client of perjury in the reinstatement petition, even after giving Mr. Bonsib 2 choices. Take a look at Exhibit W. The choice that Mr. Singh could petition for reinstatement, or secondly, she could file a PDRA, and then he would be precluded from filing a reinstatement petition during its pendency. And then when he takes the first option under my representation, he's accused of lying about the lack of a complaint. And I'm accused of bad faith in not providing you a litany of all of the things that happened before. I followed the rules in filing that reinstatement petition. That petition contains all of the required contents under the rule in the context of a 60-day suspension. I didn't suborn perjury, and my client didn't commit perjury. There was no pending disciplinary action at the time of that reinstatement petition. That petition for disciplinary action was filed concurrent with Ms. Lawless's response as a way of saying, but look, there was this complaint and you lied. My client didn't lie. My client didn't misrepresent to this court. Bar counsel misrepresented those facts to this court.
Mr. Kramer, I understand your passion. I just have a question, something about the timing. Bar counsel has indicated that the investigation ended in March 2021, and there was a decision that the petition for disciplinary action would be filed at that time. So we know that the petition was then filed July 30th in response to the petition for reinstatement. Were you in contact with Bar counsel's office between March and July? And what was your understanding of the reason for the delay or the not filing of the petition in March?
I was retained in July, Your Honor, and I was given by Mr. Bonsib all of his notes, including Exhibit W. After March 9th, when she promised she would file a petition, they then have not a phone call, as Ms. Lawless told you, but a Zoom conference in which she provides 2 choices. So she's no longer saying, I'm definitely going to file a petition for disciplinary action. She's going to say, you can file a petition for reinstatement, or I could file a petition for disciplinary action, and then you'd be precluded from filing it. One or the other. He chooses number 1, option number 1. And when he does, we're accused of bad faith in filing a reinstatement petition. That's what happened here. And that contrasts with what Bar counsel is telling you now.
Mr. Kramer,
Yes.
in Mr. Bonsib's December 2nd, 2020 email, he stated that Timur Edib and Veronica De La Vega were managing the practice. And that and I think Mr. Bonsib indicated that if additional bank records were sought, they didn't have them, so Bar counsel would have to go subpoena them. And he didn't appear to be objecting to that. Do you know whether? Well, I guess my question is, what's your response to Ms. Lawless's contention that $300,000 went into the account and were unaccounted for? That no adequate explanation has been given as to where that money came from and where it went.
Not true. Ms. Lawless was given all of this documentation. She still to this day hasn't read it. I mean, the fact is that she's accusing my client of signing trust checks. My client never signed any trust check during the period of his suspension, not at all. Talking about operating account checks, but more to the point, we have an affidavit from the accountant who went through everything, who accounted for everything. All of this documentation was provided. There is nothing new under the sun. There is nothing to show that my client was siphoning money or making money off the practice of law. Nothing of the kind. If you're going to ask for these records, and believe me, reams of records have been produced far beyond the scope of the rule to which she's entitled, you've got to read them. These documents were provided.
So describe for me what documents were provided specifically. What were the
Financial
features?
statements, bank account
When you
statements.
say financial statements, are we talking about trial balances, income statements, balance sheets?
Yes, and tax returns as well.
Were general ledgers produced?
Yes, general ledgers were produced, other financials were produced. You can take a look. There were multiple categories of records. Every time they produced more records, they got a request for more
What
records.
accounting system was used by the practice?
I can't answer that, Your Honor. I should know, but I do know that a lot was in the wake of this suspension revamped, because one of the issues, as you'll recall in the underlying case, dealt with his management of accounts. So there was a lot in transition, and Bar Counsel knew this, and Bar Counsel already had a fair amount by way of financial documentation. And then she got more. And ironically, some of her requests were for records that predated the suspension. So none of this really makes any sense. The fact is that there wasn't any financial impropriety. There's an allegation of financial impropriety, but there's absolutely no evidence of that. And Mr. Bonsa bent over backwards to provide all of the documentation requested. It did take, in one instance, months to complete a scavenger hunt because Mr. Singh's accountant was out of the country and he had to actually get the accountant's assistance with that. But the fact is that these were documents that were indeed provided. Ms. Lawless tells you, well, I didn't know anything about, them calling or whatever. All I know is I have letters written in English. Well, letters written in English do not violate the rule. Not to mention that although many of these clients didn't speak Spanish as a first language or speak English as a first language, they certainly understood some English. But all of these clients were called. You don't have an obligation to keep laborious phone notes and things of this kind. But if you want to frustrate somebody's reinstatement, you pick apart every little detail and say, well, I don't have this, I don't have that. It's obvious to me from the tenor of these communications that we were never going to satisfy Bar Counsel. And candidly, I will tell you, Mr. Bonsa is a far more patient man than I am, because I would have filed it over 800 days ago to get this man reinstated. There may have been some flaws in execution, but the fact is that she also has an affidavit indicating that those USCIS filings that Judge Booth inquired about were signed on August 13th and mailed on August 14th. She claims tracking information from the Postal Service that does not corroborate that. In fact, it does. It didn't arrive at a regional distribution center until the very day of the suspension. That's not when it was mailed. It didn't get there instantly. And we also know that it took this express mail a few days to get to its destination, which is another unusual circumstance here, but not one that is blameworthy on my client.
Is there a document you can point me to that demonstrates the source of the funds that were received and the use of the funds to which they were put?
Not offhand, Your Honor, because it's not handy to me at this moment. There are a large number. I mean, we're talking bankers' boxes full of documents that were
Right,
produced.
but is there anything that were filed in any of the parties' respective filings that could help me determine what was provided?
In the record that's before you, I don't know. I know there are bank statements and things of that kind. certainly if Ms. Lawless had evidence showing some degree of impropriety, she has not included those in her exhibits. There is no evidence to indicate any financial impropriety on the part of Mr. Singh. He didn't profit from the practice of law. The licensed lawyers were paid for the services that they rendered. The payments may have gone through the firm, but they are the ones who benefited from it. As far as the PPP
Mr.
loan,
Kramer, it looks like to Judge Gould's question, the accountant's affidavit, which is Exhibit X, reflects that not only did she prepare the tax returns, but she performed reconciliations and analyzed transactions on the bank statements and the disbursement of funds. She created new accounting records for the trust account using QuickBooks software. It looks like, would that exhibit show that we might not have the records in our possession, but we have an affidavit from the accountant who reviewed the records and provides her analysis of those records?
exactly, and that accountant actually was helping to clean up some of the issues that were identified in the underlying case, Your Honor. So Mr. Singh is doing his best, working with counsel, working with accountants to do the right thing. This is not about a lawyer who's trying to shirk his obligations or thumb his nose at this court's suspension. If anyone's thumbing their nose at a 60-day suspension, Bar Counsel's trying to treat it now as though it was an indefinite suspension. She even wants you to apply a rule pertaining to indefinite suspensions. That's simply not appropriate here. That's not what this court intended. It's not what the majority of this court voted for, and it's not what this court's judgment provides for.
Pardon me, Mr. Kramer. Did the reconciliations that the accountant refers to in her affidavit, have those been provided to Bar Counsel?
Everything that's been requested by Bar Counsel has been provided to Bar Counsel.
Well, I guess that's not, I mean, I'm zeroing in specifically on those reconciliations, the materials that from which the accountant makes her statements. Have those documents been provided to Bar Counsel?
I do believe, Your Honor, that they have. The fact is that Bar Counsel asked for all these documents, hasn't produced one that shows any impropriety on the part of Mr. Singh, not one. So we're talking about upon information and belief. That's the allegation that's contained in her objections to reinstatement, and the same allegation upon information and belief in her petition. When Bar Counsel tells you that something is upon information and belief, it means she has no evidence of any impropriety. That's the translation that I am always followed when it comes to Ms. Lawless.
I have another question, Mr. Kramer. I was looking at the bill of sale relating to tax and immigration solutions, and it reflects that there's another document, a memorandum of understanding between these parties that includes the sale price. What else? I mean, what other than the specific amount that Mr. Edib has paid, what else is covered in this memorandum of understanding? At least I haven't seen the memorandum of understanding.
And we haven't produced it, Your Honor, because it contains things that I do not believe are relevant in this matter. I will tell you, I haven't seen it either, in the sense that, though I understand what it provides for, basically what Mr. Singh did was walk away. He walked away. He put up his white flag and walked away. And I told him, I said, listen, I said, you got to fold this law firm because, you know, Bar Counsel is contending that there's this, I mean, the bottom line is it's losing you money, sir. It's losing you money, Raj.
What's happened to the staff who were employed there? Who's paying them now? Are they still working for the firm?
I don't know. I think that they are. Mr. Edib actually leased space to Mr. Singh. So it's possible that they're still on board. I don't know the answer to that question offhand, though. So I think there were some flaws in execution. Bar Counsel wants to say, well, we didn't in any way comply. That's not true. As far as disciplinary authorities, they were notified in a timely manner, including the immigration agencies. DHS and EOIR actually knew before the suspension even took effect and filed an August 14, 2019 notice of intent to discipline. And even with that information, Bar counsel then goes to her counterparts at these agencies and gets letters saying, well, Mr. Singh never told us about his suspension. First of all, I don't know how they would have learned that quickly if he or someone in his employ didn't tell them. But the bottom line is they already knew. They knew. He has an obligation within 30 days of his suspension to notify all disciplinary authorities. Well, before the suspension even took place, they're filing a notice of intent to discipline. I need to tell an agency that already knows the same information I've just received in the mail from that agency? That's ridiculous. They knew. The clients knew. There isn't any evidence of the unauthorized practice of law. What we do have here are dilatory tactics. This court enters a 60-day suspension. Bar counsel sees no urgency in enforcing it. Sends us on scavenger hunts, fails to review the documents in a timely manner, repeatedly apologizes for failing to do so, at least admits today, to her credit, that she wasn't as responsive as she should have been, and then claims to have completed an investigation on March 9, 2021 to deter a reinstatement petition, but then fails to follow through, and in a later Zoom conference gives my client two choices, one of which he takes and is accused of perjury for taking it. That's what it's like, Your Honor, to deal directly with bar counsel in the state of Maryland. I understand Mr. Bonseff's frustration because I've been there myself in many, many cases. It's high time we understand that the rules of ethics ought to apply to everyone, that everyone needs to exercise fairness to the opposing counsel and party, that we must refrain from dilatory tactics, that we must not engage in conduct prejudicial to the administration of justice, or make misrepresentations of fact or of law. We have that type of misconduct in this case, but it is not misconduct on the part of Mr. Singh. He should be reinstated immediately. There is no basis to deny that. And there is no basis for this court in its original jurisdiction over disciplinary matters to entertain a petition that was filed in bad faith and for purposes of suggesting that there was this complaint all along that precluded a good faith filing of a reinstatement petition. If this court wishes, I'd be happy before close of business today to file a motion addressed to this court's original jurisdiction to dismiss that petition for disciplinary or remedial action, because it is not filed for proper purposes. I always thought that before I file something, before I sign my name to something and file it in a court, I need a substantial legal and factual justification. Where's the justification that we committed perjury or that I suborned perjury in filing this reinstatement petition? Where is there any evidence upon information and belief that somehow we committed the unauthorized practice of law or blatantly and deliberately and willfully violated the terms of this court's suspension? Bar counsel seems to think that if she just threats or intimates that she might file a petition for disciplinary action, that somehow that should preclude any lawyer from moving for reinstatement. If that's true, her mere expression of dissatisfaction would convert all of this court's short suspensions into suspensions of indefinite duration. If I were in Mr. Bonseff's shoes, I wouldn't have entertained all this scavenger hunt nonsense. I would have filed a petition for reinstatement. Perhaps he should have done so much, much earlier. But I can't fault a lawyer for trusting his opposing counsel, particularly when his opposing counsel is bar counsel, a person that you're supposed to be able to trust and rely upon, for doing so and thinking that if he simply complies, he'll get her support and Mr. Singh will be reinstated.
Mr. Kramer, did bar counsel, you've referred many times to the request for information as scavenger hunts. Did bar counsel ask for any documents that wouldn't ordinarily be reasonably expected of a business, of a law practice to maintain? I mean, it doesn't mean that every law practice has to have it.
No, but in the context of a 60-day suspension, I mean, what happens in an indefinite suspension or a suspension exceeding 6 months is there's a rule for that. And it provides that you have to provide bar counsel with all of these financial documents and the like. But that's not what applies to a 60-day suspension. Simply does not. I'm not saying that in the abstract there's anything wrong with that. And that's why I don't have a problem with Mr. Bonson producing it. He felt that if he just exercised good faith and cooperation, he would meet the same in return. Unfortunately, that didn't happen, Your Honor. And so what we have here then is a petition that brings charges that are simply not grounded in fact or in law. Judge Gould, bar counsel told you that it is not required that my client divest himself of ownership of the law firm. She said the same to Judge Booth. She said something different to her opposing counsel in Exhibit W. And you take a look at this. In the middle of the page, he should not have an ownership in the law firm. She asks, who owns the firm? She believes all the firm's accounts should have been closed. Not true. And nothing operating under the firm's name during the period of suspension. Absolutely not true. And there's a rule to that effect that in cases where the suspension is of definite duration, 6 months or less, you can maintain all of those operations. You can maintain your firm name, your website, the listing in the phone directory, and all of the rest. You do not need to shut down. If that's the case, then what this court does when it even suspends for 30 days is it decides, if it takes bar counsel's interpretation, that you must shut your entire practice down, close up shop, and at the end of 30 days, you've got to start your career over again. I know bar counsel never maintained her own law practice when she was an attorney. I understand that. But I have, and I'm going to start over after a 60-day suspension. Well, you have to if you're Mr. Singh and you've now served 878 days of that 60-day suspension. It is time for this court to inform bar counsel and everyone that when it enters an order and imposes a sanction on an attorney, it means for that order to be enforced by bar counsel and everybody else. My client did not violate that order.
I have a question. I'm just looking at one of the checks that's in the record before us. This is a check drawn on the operating account of the firm, October 8th of 2019. It's made out to the U.S. Department of Homeland Security in the amount of $725. The memo line lists what I assume is the name of a client whose last name begins with A, and it says Form N400. Was it on your view of the rules, was it appropriate? Was it proper for, I don't know, I'm going to assume this Mr. Singh signed this, but was it proper for him to do that, to sign that check and pay something to Homeland Security through his operating account?
Well, certainly a lawyer can certainly pay advance costs through their operating accounts, but I know what you're asking. And I would not have wanted my client to do that. Now, he wasn't acting under advice of my counsel. He was working with Mr. Bonson. But Mr. Bonson provided this information and even wrote about it to bar counsel and thought that actually there was nothing wrong with it. Now, I do not concur, but that's what I mean when I say, Your Honor, flaws in execution. There were some things that I would have done differently. I would have had earlier substitution of appearances of counsel in certain of these cases. I wouldn't have added his wife as a director. He thought, and presumably Mr. Bonson in Exhibit I at 102 of our appendix, seemed to feel that that was an appropriate way of getting Mr. Singh out of the management of the operation.
Do we have do we have an affidavit anywhere from Mr. Bonsab that discusses, I mean, we've talked about advice of counsel. Do we have anything from Mr. Bonsab, an affidavit or anything that says what his actual advice was to Mr. Singh on any of these?
Well, take a look at Exhibit I, page 102 of our appendix, Your Honor. Mr. Bonsab speaks about writing to Bar Counsel and saying, you know, this is what was done by Mr. Singh in order to essentially honor the suspension. And I should say that this is action that was done on August 17th of 2019. Now, unless you're crazy and you're already under the microscope, right? You've just been suspended. You're not going to do something deliberately to thumb your nose at this court. That's not what was intended here. He thought, I believe mistakenly, that he was doing the right thing, but it was clumsy. And there's no getting around that. But that's not the type of infraction. Even if all that's true, what would this court do about that problem? Suspend him for another 800 days? I mean, he has more than paid the price. He's entitled to get his life back, and that's what I ask of this court. Thank you.